all these bottlenecks preventing speedy prosecution of criminal cases have been removed. Now, adjournments have been limited. You can no more file objections to a charge and ask the judge to stay action. Even stay opposition have been suspended.
Is the law being implemented?
Except for the one that happened at the Code of Conduct Tribunal. I think most of the judges are implementing most of these things. But the problem is that on the issue of adjournments, people have canvassed that's against the principle of fair hearing as enshrined in the Constitution. But apart from that, the courts have appeared in. Most of the judges are implementing most of these rules.
So you do not see that there is a need to have special courts as a result of that?
I don't think there's a need for a special court. If we now have the ACJ doing all these things, telling you, young man, you don't make adjournments for more than 5 times. You don't stay proceedings. If we have these things, these laws, you don't need special courts anymore.
But some people will still ask, why is it then that we've still not seen the speedy delivery of judgment in some cases that seem to have been in the courts since forever?
I don't think since the coming of this act that cases have been prolonged. I don't think so. If you go to the courts now, most of the cases that have been, most of the criminal cases that have been commenced when this act came into being, if you check it very well, most of them have gone to the stage of final addresses.
So are you talking about the way it works? Is it that it will only apply to cases that started after the act was enacted, or would it also apply to cases that have been in court before the act came to being?
No, there are provisions where in the act where even cases that have started, that can also, there are parts of the act which allows you to also adjust and follow the proceedings of the act.
So far, so good. I mean, you've talked about this committee set up by the National Judicial Commission, headed by Justice Salami, and we've also talked about special courts. Only recently as well, the NJC wielded the big stick. Some judges were let off, for lack of evidence and lack of proof, and then in some instances, the petitioners withdrew their petitions. But we did hear that a judge was fined, was dismissed for accepting a bribe of 200,000 naira. What are your thoughts in terms of the discipline that is being wielded by the NJC? Do you think it could be faster? Do you think that the pace is right? Do you think that the process is also thorough enough?
Yes, if you look at the NJC, we must inform the public, is an independent institution. And its powers to discipline judges cannot be controlled by external factors. They have full powers. You cannot dictate to them on how they discipline judges. But the most important thing is, while we want the NJC to fast-track the process of processing petitions against judges, we should also be mindful that some of the judges also have fair hearing. So you don't just rush through, as if the person you're probably probing or investigating cannot be heard. So long as the affected persons have been heard, you must balance both sides. But so far, so good. As far as I'm concerned, the process being adopted by the NJC in the past couple of years have been impressive. And most of these petitions that go to them have been treated with dispatch.
What more do you think needs to be done? I mean, you have said that you're given the current Chief Judge of the country 7/10 for the reforms that he's instituting in the system. But what more do you think needs to be done to get us at least closer to 9, if not 10/10?
Being the head of the country's judiciary is not a tea party. And Nigeria is a country governed by laws. And the Chief Justice of Nigeria also respects the Constitution. And like I said, he has been there for a couple of months. We never can tell what he has in stock for us. He just set up this committee. And let us see how this committee goes in the issue of discipline of judges. Perhaps the only area where one cannot say the NJC should take a look inwards, or probably they should talk about the issue of restructuring the NJC.
Restructuring?
So, yes, in the area of even the CJ and itself being the chairman of the National Judicial Council. Let me give an instance. If I have a petition against the Chief Justice of Nigeria, who is the chairman of the National Judicial Council, who sets up a committee to investigate him? That's the question. So I think some of these areas needs to be reviewed so there can be safeguards, mechanisms for checkmating, even those also heading the NJC.
How do you think that safeguard can be created?
There's a commission called the Federal Judicial Service Commission. And I've been asking some of my colleagues, the National Judicial Council, by virtue of paragraph 21 of the part 1 of the third schedule to the Nigerian Constitution, spells out the functions of the NJC, which includes appointment of judicial officers. Now, what about the Federal Judicial Service Commission? They also deal with appointments. So
do you want them to be married, or should
what
one
I'm saying,
be...
as part of the instruction I just said earlier on,
yes,
probably the NJC should be tasked with the duty solely of disciplining judges and leave the other aspect of appointments and administrative functions with respect to the judiciary to the Federal Judicial Service Commission.
How would that help?
Yeah, it will help because it will enable the NJC to concentrate more on discipline of judges. That is what Nigerians want to see. Nigerians want to see how a corrupt judge, in quote, can be quickly dealt with, investigated, and probably you have the petition against the judge wrapped up under 3-4 months. So if they concentrate only on looking at petitions, disciplining judges, and forget about budgets of the capital budget of the judiciary, the appointment of judicial staffs and judicial officers, and leave it for the Federal Judicial Service Commission, it will help to quicken, like you said earlier on, the quick processing of petitions against judges.
Some people will say what you're asking is that it becomes a quasi-court, and that is all the duties you want assigned to it. But then, people will also believe, or some people will also say that perhaps it should also be burdened with the larger question of reforms within the judiciary. In terms of infrastructure, how would you say that the judiciary is doing? Are they improving, or do you think we're still where we are, or getting worse?
I think sometime in 2011 or 2010, the president of Court of Appeal had the honor of taxing me and my firm to do visitations of some of the courts, Court of Appeals. I went to Enugu, Court of Appeal. In terms of infrastructure, it wasn't anything to write home about. But do you blame them?
So there's still a lot of work to be done in that area.
Yes, it is not the issue of the infrastructural development of the courts is not in isolation. You have to look at one, for instance, what the country can afford at a particular point in time, and again we have to look at the issue of how funds are being utilized by the heads of the courts.
What about judges writing in longhand? Is that still an issue?
No, some of this, well, some still do it. Although if you go to some courts, I think there are machines placed before the judges that enables them to record what transpires in court, and they can also play it back. I think the issue of writing in shorthand is just enable them to take notes of major points.
Well, Mr. Ugochukwu Oswago, we have to thank you most kindly for coming on Sunrise Daily. He is a legal practitioner. Well, Sunrise Daily will continue in just a moment with another perspective on the same matter. Please stay with us.